Hi there, Attorney Nicole Laruwe here, joined by Attorney Julie Paquette. We're estate planning and probate attorneys, and we're here to bring you part 2 of our frequently asked questions and answers. And the first question that I have for Julie is there a reading of the will?
Okay, I love this one. And it's easy to answer. Basically, real life is not like what you see on TV. So, we all know the movies or the TV shows that start out in, the big fancy lawyer's office with all the leather furniture and everything. And there's going to be a reading of the will, and it's very dramatic. And then people will be shocked to learn that they've been cut out or that kind of thing. Or the girlfriend gets everything and the kids get nothing, that type of thing. That's really not how it works. Generally, how you find out what is included in a will after someone passes away, oftentimes will just be informally receiving a copy of the will from whoever may have it, or you could be sent a copy of the will when you're served with the opening documents to open the probate estate. So unfortunately, it's not that dramatic. Okay, so Nicole, what about attending court? Do the clients have to appear in court and get on the stand?
Clients ask me this every time I talk to them, and it's similar to the response to your question, or your answer, Julie, is it's just simply not like the movies or like TV. You don't need to appear at court. Right now, actually, everything's via Zoom. So all the court hearings that we're attending are over the computer. We don't have to attend right now either. But in either case, you've hired us as your counsel. We're here for you, and we're going to handle everything. And that includes going to the hearings and appearing on your behalf and making sure that we've taken care of everything that you've asked us to. So short answer is no, you do not have to appear at court. All right, so my question for you, Julie, is I did everything for my mom. I took her to her doctor's appointments. I bought her groceries. I took care of her every need. What do I do now?
Okay, so this is one that's a little tricky, and you should just be cautious in really making these claims like this. When you say, you took care of this other person and they relied on you for everything, and basically they wouldn't be able to do anything without you. Yes, in all likelihood, you're taking care of that person out of the goodness of your heart, right? You're giving up your time and energy and you're helping this person out because they need your help. But on the other hand, you could be setting up an argument for undue influence. So this is a case where someone could come in and say that this individual included you in their will, or gave everything to you, or maybe deeded their house to you. And that was only because they were completely reliant on you and they didn't have any other assistance or any other help. And that basically you put pressure on them and you had access to them. And it can be a tricky situation. So I get a little nervous when I hear people, making these claims that they did everything and this person completely relied on them. And I'm just kind of like, okay, well, let's, talk about this. And on the flip side is when you're on the other side of it, that again, this is just an opportunity for litigation and driving up costs and having an uncertain outcome in an estate administration when you have a case like this. So, okay, next question is, oh, this is a good one too. Hey, Nicole, my stepmother called in an attorney while my dad was very sick in the hospital and he was dying. And she called this attorney to come see him in the hospital. And shortly before he died, she had him sign this will that gave her everything. And now he's passed away and she's got access to all of the property. And she's, giving away all this cash to all of her kids, and we're going to get nothing.
Yeah, that's a very concerning topic that we've been asked about before. And what we can tell people is it's kind of similar to the dementia question, where we have to establish, did that person have capacity to sign these documents on their deathbed while they're at the hospital? Sometimes, you know, an attorney goes, and if they sign the documents, they establish that capacity, that's great. On the other hand, you know, you don't know if that attorney was doing the things that they should have been doing, or the stepmom was doing the things that she should be doing correctly. And this is just another instance where it might open up to litigation again. So it could go both ways here. If you find yourself in this situation, I would advise you to give us a call so we could walk you through it. But it could go either way here. It could be a totally legitimate transfer where she's signed off legitimately with capacity to sign those documents, or there could be some undue influence or other situation there where litigation could have to come up and play.
Yeah, exactly.
All right. So the last question I have for you, Julie, is my mom always said I would get the house, and now she's died. And what do I do about this? She told me I'd get it.
Yeah. And then you find out there's no instrument that actually provides for you to get the house. So this is another one that comes up quite a bit. And this may be, you know, maybe the parent promised the person the house in exchange for helping them out, or some other reason that the parent wanted the one individual to get the house. And, you know, hey, everybody in the whole family knows this was always the deal. You can ask my aunts and uncles, right? And everybody knows in the family I was supposed to get the house. But without the legal transfer to you, this is a tough one. The individuals, you know, say for your instance, your siblings, they would have a really good argument for saying that, you know, if mom wanted to transfer the house to this person, there were ways to do that. And she chose not to. You know, this is just a mere promise that she made that she was going to transfer the house, and she didn't for whatever reason. She chose not to, and we're going to abide by her wishes. On the other hand, the individual who was promised the house may have some other good legal arguments to make of why they are entitled to the house. So this is not a clear-cut one, not so much. And again, it's just a really good example of how it may just open the estate administration up to litigation. And again, an uncertain outcome coupled with the fees of getting into litigation with your siblings or other family members, depending on what the situation is. So again, this just comes back to the importance of having good planning, having documents in place, and having planning done. Really, that's with an attorney who practices probate and estate planning, not just an attorney who thinks they can draft a will just because they're licensed to practice law, which, you know, technically they are entitled to draft a will or prepare a deed. But really, you should meet with somebody who can look at the whole picture and understand how these documents work together and get you, you know, to where you want to be, accomplish your objectives, and reduce those chances for extra costs later, or litigation and the difficulty and the strain and the costs that's involved with that. So we hope you enjoyed our top 10 frequently asked questions, and check back soon because we will certainly be doing some more. Thank you.
Bye.